Up is Representative Rob Sampson, Representative Sampson, followed by Poe Murray from Newtown.
Good morning, Chairman Larson, Chairman Dargan, Ranking Member Guglielmo, Ranking Member Zupkis, and distinguished members of the Public Safety and Security Committee. I am here to testify in opposition to the bill that we've just been hearing about, House Bill 5408, an act concerning the presentation of a carry permit. My written testimony is pretty long, so I'm going to just try and keep it to the highlights here today. I know that we have a lot of people who want to speak. I want to quickly note that the statute that this bill attempts to change was just passed. It was passed, in fact, on the last day of the last session, June 3rd, 2015. And I will also note that it was passed as a result of a bipartisan agreement made by all of the leaders, and it was also voted in unanimously by every one of you and myself and the rest of the 187 members of the House and Senate, with no opposition whatsoever. I also think that was in result, that bill came before us last year because of the same incidents that bring it back this time around. So the proposal before us is just a simple change to remove the words "who has reasonable suspicion of a crime" from the requirement compelling a citizen to submit to being detained and possibly searched by a police officer because they are openly carrying a firearm. I want to state for the record, just very briefly also, as Leslie Zupkis did, Representative Zupkis, that I strongly support the brave police officers that serve with dignity throughout our state. I know many police officers personally, and I know them to be honest and courageous people doing a very dangerous and sometimes impossible job. I have no interest in making their lives more complicated, difficult, or dangerous. However, we all have to live under the same rule of law. And as was already brought up, and I'm very pleased that the committee saw fit to actually make this quite clear right out of the gate, this is not a gun issue. This is a civil rights issue. And I would urge each of you who are concerned with protecting the civil liberties of your constituents, pay special attention to how this will affect you, the people that you represent, and just think about how it might be if your constituents could be detained or even searched despite a police officer having no reasonable suspicion that they have committed a crime. As was mentioned, this is the same exact reasonable suspicion standard that a police officer is required to have when he pulls over someone driving down the street. It's an extremely low bar. The testimony that we just heard about what might happen in a McDonald's if someone called, I think that rises to reasonable suspicion. If someone calls and says that someone is displaying a firearm, was mentioned, I think that rises to reasonable suspicion. Simply someone having possession of a firearm, I don't think does. But I'll just move on. We can talk about what reasonable suspicion really is, and I think we ought to get into how low a standard that is at some point to make it very clear as far as this proposed change. The reason this is so important to our system of justice is to ensure that we all have equal protection under the law. Saying that someone who is acting lawfully, which includes the open carrying of a firearm in Connecticut, has less rights than someone else cannot be tolerated. There was a discussion about someone walking down the street earlier. And the issue with that is that if someone is walking down the street and the police have the right to walk up and ask them for their documentation and detain them just because they're openly carrying a firearm, essentially, which is no crime, that means that could happen numerous times a day. You are essentially giving law enforcement an opportunity to harass someone because of a perfectly legal and lawful activity. We don't do that for anything else, and I don't know why we would do that for this specific activity.
Representative, if you could summarize, please.
I will just say finally that no matter if we pass this bill or not, and this actually becomes the law, and we take these words out of the language of our statutes in Connecticut, it's not going to change anything. The law of the land is the Fourth Amendment to the United States Constitution and basically preserves the fact that citizens have civil liberties and that reasonable suspicion is required. And if we take it out of the words of the law, it's still going to happen. The situations that were mentioned will occur in the same way. The courts will still have to make the same decision based on the same facts in the case because that reasonable suspicion is still required, whether we put it in the law or not.
Thank you. Representative Dargan?
Good afternoon, Representative Sampson. You
Always good
didn't
to
even
see
get
you.
an opportunity to talk about a bill that we talked about, uniformity of permitting within the state, and it seems to be an issue within the respective towns, what one police chief wants to do in a community compared to somewhere else within the state. So it has merit to say, okay, let's have some uniformity when you're applying for a permit. So I just want to give you a minute to comment on that bill, if you'd like.
Yeah, thank you very much, Representative Dargan. I really appreciate the opportunity. This is a bill that we've had before us, a couple of times in the past. I think it's House Bill 5409, and essentially I would certainly strongly support that bill. I would have liked the opportunity to testify in favor of it. I'll take a second just to agree with the good representative to say that this solves a problem where different municipalities are coming up with different types of criteria necessary for applicants looking for a pistol permit. The bill simply states that they would have to use uniform criteria across the board. It does not restrict the ability of a police chief to make a decision based on the suitability of a person. It just says that they have to stick within certain guidelines rather than making it much more difficult than it has to be.
Thank you.
Thank you, Representative. Representative Straczynski?
Thank you, Mr. Chair. Good morning. Good afternoon, Mr. Representative Sampson. In the bill that's presented, and you mentioned in your testimony the open carry aspect of Connecticut's laws, the bill doesn't say anything about open versus concealed. Do you have any concerns on the difference between the two? I think, looking at this proposed bill, there's obviously a difference between someone who's open carrying versus concealed carrying and the level of suspicion they may or may not arise to the general public, and then a police response in response to that. So I just would like to hear your take on the difference between open versus concealed, and if this bill were to progress in any way on this committee level or on the floor, would there be a difference in the language, open versus concealed, and how do you feel about that?
Thank you for the question, Representative. And this really goes to the heart of the matter. The fact is that in the eyes of the law, there is no distinction between open carry or concealed carry in Connecticut law. Both are perfectly legal activities, just like mowing your lawn or being of a different race. And if we are going to write laws that say that law enforcement has the opportunity to specifically target and detain someone who is engaged in a perfectly lawful activity because that lawful activity causes some other people to be upset, then we've gone down a dangerous path. I think Senator Guglielmo laid it out very, very well with his Latin Kings example. The fact is that we live in a very diverse society. People are alarmed by all kinds of things. If I call the police because, Representative, you are mowing your lawn and it's bugging me, the cops are not going to come and show up for that. They're going to say mowing your lawn is perfectly legal and leave the guy alone. And that's what should happen in a case like this also. It's the same thing if you see someone who looks out of place in a store or something like that. There is a distinct line between what's lawful and what's not, and people should not be targeted and not lose their rights for being engaged in lawful activity.
Senator Gomes?
How you doing this morning?
Always good to see you, Senator.
I just heard you say something about this being a civil rights issue, and you talked about the Fourth Amendment. And when we talk about civil rights issues, you said everything is equal under the law. But you do recognize the fact that all the standards are not equal under the law. There are certain standards that might support one bill and or one situation, and other standards that might support another situation. This open carry bill, I don't have a problem with open carry. But do you have a problem with, evidently you do have a problem with somebody saying you have a reason to believe in order to approach somebody carrying a gun. That would mean that you if the gun's in plain sight, you wouldn't have a reason to believe that he's carrying a gun. You don't, reason to believe means that if it was concealed. Do you believe in the difference in that?
I'm not quite sure I follow you completely, Senator, but I
Well,
will-
the language says that if law enforcement officer has reason to believe such holder is carrying a pistol. Now, if it was openly displayed, he wouldn't have reason to believe, he would know that he's carrying a pistol. We're talking about the part that if maybe he had a bulge in his pocket or something like that. You have a problem with that, about him approaching him and asking him then?
to be honest with you, I have no problem with law enforcement approaching anyone and asking whatever they like. I mean, that's perfectly legal in our society. That's a consensual conversation. What I have an issue with is when law enforcement has the right to detain someone just because they are in the process of doing something that is completely lawful. I mean, someone cannot walk up to you and demand your information and detain you and potentially search you because you're mowing your lawn or because you are, doing anything else lawful. So why, if we have a perfectly lawful activity, which includes open carrying a firearm in Connecticut, a law enforcement officer can forcefully ask for your information? He can certainly ask you, and I think in 99% of cases, people will voluntarily give up their permit and their information. The few incidents that occurred, that we talked about, I saw them all. I watched the videos and so forth. If the police officer was properly trained at the time, he would have known that he needed reasonable suspicion, just like pulling over a car on the road, to engage that person the way they did. And in almost every one of those cases, if they had stated what that reasonable suspicion is in an articulable way, as is required, the whole thing would have been avoided. The reason why this is before us is because I think the law enforcement officers involved didn't know their job well enough. I think they need to be trained very simply. All you need to know when you see someone open carrying a firearm, if you want to go engage that person in a conversation and you want to demand their credentials, you have to have the same exact level and standard that you do when you pull over a car. And it's a ridiculously low standard. I mean, a police officer could probably pull you over because you're driving a dark-colored sedan, just to say, oh, well, a dark-colored sedan was involved in a crime yesterday. He probably has that same ability to ask somebody who is open carrying a firearm. Certainly if someone complains and says that someone is displaying or brandishing a weapon, that's reasonable suspicion. They can go and ask. And I think that any person who is lawfully carrying a firearm, openly or otherwise, would voluntarily submit to that. It's when you get to the point where we are going to draft a law that says, well, that's out the window. You don't need to have any rights anymore. If you are carrying a firearm, which is perfectly lawful in Connecticut, you have to give us your information. And that implies whether we ask you 10 times a day or 10 times a year. Imagine how that could be abused. And imagine if that's extended to any other lawful activity. That's why I'm here.
Well, then you believe that if a person was asked to show his permit to carry that weapon, he has a right to say, no, I'm not going to give it to you, and that's perfectly all right?
If there is no other reason and the cop cannot explain why he's asking him, then yes.
Well, the cop would be asking him because he has an open weapon, and if you have an open weapon, you should have a permit to carry it, and he asked for the permit, and he refused to give it. You feel like that's perfectly all right?
I do. Same reason why a police officer cannot pull you over because you're an African American and ask for your identification to make sure you're a legal citizen. It's the same exact reason.
Well, thank you.
Senator, Representative Berenger.
Thanks. And you Representative, you said something interesting, and I believe it. You'd said that the police officers asked a legal gun holder, permittee, if they had a permit, that 98% of people would do that.
Right.
I know a lot of gun holders, they're responsible, and the ones that I know, they would be more than happy to show it. So I respect those who are out there and have permits, and are responsible permit holders. But I do have a question, and I don't know if you heard me earlier. I gave a quick scenario of, police officers were called to a McDonald's because individuals in there were alarmed because they either saw a gun. But because the police officer didn't see the gun, they don't, the person, as part of their investigation, the person that they're talking to refuses to show the gun. So the officer has no other choice but to walk out of the McDonald's. So let's just take that a step further. Let's say the officer leaves and there's a mass shooting inside that McDonald's. Children shot, whatever the case may be, maybe a relative. If that was a relative or someone you knew, and if it would require that person to show a permit, do you think you would have a different view today?
Forgive me, Representative. I just think your scenario has a lot of assumptions in it that aren't fully fleshed out. I mean,
Well,
I
I'm
think
just giving you a scenario.
Yeah, well, I mean, in the scenario, you don't state whether or not there is going to be reasonable suspicion for that police officer to be able to ask that person, and I believe that there is. I believe the cop can go there based on a complaint. Certainly if the complaint says that the person is agitated or acting in some kind of manner, I would say that any attorney would say that meets the requirement for reasonable suspicion. The cop has every right to go and detain that person and ask them for their
But you had said
identification.
earlier, though, if the only thing that person did was cause alarm, and it was just a conversation that, geez, anybody can cause alarm. It could be a Los Solitos, it could be somebody mowing the grass. That's not what we're talking about here. We're not talking about racial profiling. That's for another day. We're talking an example where an officer is somewhere where they're legally there.
Well,
And the only thing we're asking in this example, as part of that investigation, is for that person to show their permit. That person, under the existing law, as you know, and this is what the debate is today, is they don't have to show it. So the officer leaves, and then we have, unlike, in the last few years with all these mass shootings, it's not a hypothetical, it's a reality, it could happen. So I'm asking you, if given that situation, if it was a family member of yours who was involved in that, do you think your testimony would be different today? Yes or no?
Forgive me, Representative, it's a ridiculous question. It just really is. It's a positively ridiculous question. There are no facts surrounding what you're describing. What you described as the scenario and what we are talking about is the exact thing we are talking about. If that person is sitting in a restaurant and he is openly carrying a firearm, but not displaying it, not doing any other activity whatsoever that should alarm anyone, then if someone calls, then they should be instructed that person is engaged in a perfectly lawful activity. Maybe the dispatcher or a police officer might ask them, are they doing anything else? I mean, have they waved the gun around? Did they do anything that might say that they are a threat to anyone? In which case, I think the police have every right to rush down there and detain that person. But if they are merely engaged in the lawful activity of possessing a firearm, look, and again, I have not taken a position on that exact law, but the fact is that that is perfectly lawful in our state, and as long as that is perfectly lawful, it does not rise to reasonable suspicion, just like any other lawful activity does not.